Thank you for joining our special policy update on the overtime regulations. And thank you for bearing with some technical difficulties. I see my partner in crime today, Chris Williams here. So I'm gonna dive right in. Again, we're really glad to have you with us. And if you or your colleagues end up missing out on some of our content today due to technical difficulties or due to it being a really nice day outside, I need to reassure you that we will make this recording available to all registrants. So again, we're really glad to have you with us, and I will get started. I'm Ben Kershaw. I'm the Director of Public Policy and Government Relations here at Independent Sector. If you're joining us for the first time on an IS webinar, welcome. Independent Sector is a national membership organization representing a diverse set of nonprofits, foundations, and corporate giving programs, working together to ensure all people living in the United States can thrive. This is a webinar, so as part of that, your lines are muted. We will pause periodically, especially at the end of our presentation, for questions. You are welcome to put those questions in the Q&A function throughout at any point. If you're having technical difficulties, we hope you'll email publicpolicy@independentsector.org. This webinar and our webinar features are usually a monthly benefit for Independent Sector members. If you're not an IS member and you want to find out more about working with us month in and month out, we hope you'll contact membership@independentsector.org. Lastly, before we start, I want to respectfully acknowledge I'm joining you today from Washington, D.C. It's the ancestral home of the Piscataway people who are still in the area working to reclaim their land and their traditional practices. Also, many of the buildings and the places we inhabit in Washington, D.C. were built by enslaved people. Wherever you are joining us from today, we're really glad to have you. So we're going to spend a fair amount of time today specifically on the overtime provisions of the Fair Labor Standards Act, in particular, the recently finalized overtime rule. And we are very lucky to have with us an expert guest this afternoon, Christopher Williams from the international law firm Sheppard Mullin. Before I introduce Chris, I want to take 2 minutes just to share Independent Sector's perspective on this overtime. And this perspective is more fully fleshed out in comments that Independent Sector submitted in the fall. So 4 key points. First, the nonprofit workforce is a critical asset, not just for our sector, but for the nation. Independent Sector's president and CEO, Dr. Akilah Watkins, just completed a nationwide listening tour, and the nonprofit workforce was the #1 issue that she heard about. So the way that this policy gets implemented matters deeply. Second, the current threshold for exemption from overtime at about $35,000, $35,500 is too low. The final rule issued by the Department of Labor cites Dr. Watkins' comment that a healthy and equitable nonprofit workforce requires an increase in the salary threshold. Third, this increase will be hard, and it will force difficult choices for many nonprofit organizations and workers, as well as the communities that they serve. And fourth, if the federal government is going to increase costs on nonprofits, it needs to help them manage those costs. Independent Sector and others called for a phased-in approach, and to some extent, the Department of Labor adopted one in 2 steps. Again, we'll talk more about those details. Federal grants and contracts also need to be adjusted to represent and to offset those increased costs. So we're going to have time for questions about this, but now I am really excited to introduce our guest and our presenter today, Christopher Williams. So Chris serves in Sheppard Mullin's labor and employment law practice, which is one of the largest and most prestigious in the country. That Chris is choosing to be here with us today, I think just underscores his commitment to the nonprofit sector. His full bio is in the event page, so I'll spare you the long list of his areas of expertise. And the last thing I'll note as Chris pulls up the slides is that he worked as an executive recruiter before becoming a lawyer. So he's seen employment issues from that angle as well. Chris is going to cover 4 primary topics today. He's going to talk about the overtime rules in general, some of the changes under the recently finalized rule. He's going to talk about the legal outlook for the rules, maybe some court cases pending, and some strategies that workers and employers can consider. So, and again, Chris has graciously agreed to take questions at the end. You can submit those at any time through the Q&A function. With all that ado, thanks again, Chris. Over to you.
Thanks, Ben. It's a pleasure to be here. Thank you to Independent Sector for having me, and thank you everyone who is here today. I see we already have questions coming in, and hopefully we're going to cover some of those in the presentation, and we'll take questions at the end as well. So there's some very exciting things that have come out of the Department of Labor in the past few weeks, and the new rule with respect to overtime exemptions is one of those. Under the Fair Labor Standards Act, or the FLSA, as we commonly call it. A quick disclaimer to start: this is not, or is it intended to be, legal advice, and your questions welcome, but it's best to keep those hypothetical or general rather than specific real life examples. My answer, if it's a specific real life issue, is probably going to be the typical lawyer answer of "it depends," and it will be frustrating for all parties involved. So without further ado, the new overtime exemption under the Fair Labor Standards Act. What is the FLSA? It's a federal statute. It is intended to protect American employees. It's a broad act, but probably the 2 biggest things that it does is it sets the minimum wage, and it determines which workers can and should receive overtime. It also covers things like child labor, nursing, breaks for nursing mothers, and other things like that. But today we're going to be talking about the overtime provisions. So who falls under the act? Well, non-exempt employees, that's what we call them. They must receive 1.5 times their regular rate of pay for all hours worked over 40 hours a week, and they must be paid the minimum wage. Now, as you probably know, a lot of states have a minimum wage that is more generous than the federal minimum wage set by the FLSA. In that same vein, some states have more generous overtime provisions as well. So, a quick note about state law. Be aware, because some states have more generous overtime statutes. I know we have people joining from all over the country today, so it's important to know what your state overtime statute, wage and hour laws are. For example, California requires double overtime in some situations. Multiple states require overtime to be calculated on a daily basis. So if an employee works, for example, more than 12 hours, that's when the overtime kicks in. Or they have a different exemption threshold, like we're going to talk about today. But important to know your state. We're going to be talking about federal law today. So who is covered under the FLSA? Specifically, which employers are covered under the FLSA? Well, hospitals, institutions that engage in medical care, educational institutions are covered. Companies and organizations that have sales that exceed $500,000. Now, this is for profit or nonprofit. It doesn't matter. So, for example, A museum with a gift shop that has sales that exceed $500,000 would fall under the FLSA through this method. But what really gets nonprofits under the FLSA are employees who engage in interstate commerce. This is extremely broad, like right down to, for example, an employee who calls someone in another state. They're engaging in interstate commerce. So that's where nonprofits fall under the FLSA for the most part. Now, how do you determine which employees are exempt? Well, they have to, first thing, they have to fall under one of the white collar exemptions. So a white collar worker is someone who works in an office or does non-manual labor. And there are several white collar exemptions. Most relevant today, and what we're going to talk about here, are the executive exemption, the administrative exemption, the professional exemption, and the exemption for highly compensated employees. There are also a couple of others that for outside sales employees and computer employees, but I think most relevant here, we're going to cover the executive, administrative, professional, and the highly compensated employees exemption and get into detail with those. So how do you know, how do you figure out whether they fall into one of these exemptions? Well, you have to do uh, what we call the salary basis and primary duties tests. A threshold foundational issue is whether an employee is paid a salary, and it must meet a minimum. Currently, that is $684 per week, which works out to $35,500 and some change, I believe. And their salary cannot be reduced below that. That is a threshold issue. So for example, let's say you have a communications coordinator that you're trying to determine whether they are exempt under the FLSA. The first question that you look at is whether their salary is above that level, whether they're paid a salary and whether it's above that level. This is what the new rule touches. This is the only part of the test that the new rule touches. It just raises those thresholds. So your next question will be, which exemption would they fall under? Executive, administrative, professional, computer, sales. It has to be at least one, but it can be more than one. For example, a lot of times, very high level employees are going to fall into more than one, like a general counsel will probably be a professional and an executive and maybe even an administrative position or exemption. So once you determine which exemption they might fall under or which to look at, you look at their primary duties. That's the analysis that you have to perform. It's very fact intensive. It's a big factor is how much work do they spend doing exempt work? How much time do they spend doing exempt work? But it's also considers what is their freedom from supervision? What is the importance of the exempt work that they do compared to the non-exempt work that they do? And you weigh all of those factors and determine whether it comes out to be their primary duty is, yes, it is exempt work, or is their primary duty non-exempt work? And which way it falls is whether they fall into one of the exemptions or not. So let's dive into some of these exemptions, more specifically to determine what primary duties you want to look at to see if they fall under one of the exemptions, starting with the executive employees exemption. This one's, it's kind of obvious when you think about it, but there's some nuances here. Their primary duty under the executive employee exemption is going to be managing the business operations. These are department heads, C-level executives. They are going to have the discretionary authority over purchasing, schedules, departmental budgets, work assignments in the departments or in the organization as a whole. You want to see them have at least two or more full-time employees under them, and ask whether they have hiring and firing power. That determines whether they really do have sort of authority over the business operations or departments within uh, an organization. So it's unlikely when you're considering our um, communications coordinator from the last slide, they're probably not going to fall into the executive employees exemption because unless they are actually overseeing the communications department and their title just doesn't match what they do, um, they're probably not going to fall into this exemption, even if they make a salary that is above the minimum. So what about the administrative employee exemption? So the primary duty of an administrative employee is also working directly with the management of the organization, and they have to exercise discretion and independent judgment over significant matters. So where you think of the executive employees are maybe the top of departments or the top of the organization, this is maybe one step down. They will do things like tax, finance, marketing, human resources, public relations, legal compliance, government relations, those sorts of things can fall under the administrative employee exemption. But it has to be something that they have discretion over and authority with. So questions that you might want to ask when you're considering whether someone is an administrative employee is whether they provide a service. Do they have the power to make or change the organization's policies? For example, a human resources manager, do they just enforce the company's policies, or do they actually have the authority to make and change the policies within the organization's handbook? Um, does the employee have the authority to bind the organization? So in contracts or otherwise, basically, do they have the authority to go out there and say things to the public that would bind the organization? They're working on matters of significance in the organization under this exemption. And our communications coordinator, they could fall under this depending on what they do. If they're just writing press releases and submitting them for approval, probably not. That's not an exempt duty. But if they have the authority and they are regularly talking to the press and releasing press releases without prior approval, and that's their primary duty, then yeah, that would bring them within the exemption. So it really depends on the nitty-gritty of what each employee does. Sometimes it's obvious. Sometimes it's obvious that they are exempt. Sometimes it's obvious that they aren't exempt. But a lot of times you kind of fall into this gray area and you have to look at every single little thing that they do and determine what the primary duty is. So looking at the next one, the professional employees exemption. This is a twofer. There are two parts to this exemption. So the first one is the learned professionals. Um, this one's fairly obvious. It's people who do work that requires advanced knowledge in a field of science or learning. So engineers, doctors, physician's assistants, lawyers. If they have to have an advanced degree to do the work, that's great evidence that they're going to fall into the professional exemption, but it's not necessarily this positive. When you boil down what they do, they have a specialized training. And they use that training to analyze facts and make deductions and recommendations from those facts. That's what a learned professional does. Then there's also the creative professional exemption. Again, this is relatively clear. They have to use their own imagination, invention, talent, to do something that is in a recognized artistic or creative field. Cartoonists, a lot of graphic designers could fall into this, musicians, but it all depends on the level of autonomy and the amount of creative ability that is required by what they do. If they're just doing something that's rote or mechanical, that would not be exempt work. Again, our communications coordinator is probably not going to fall into this exemption. So there's the fourth one, the highly compensated employee exemption. This one falls outside of the primary duties test. It's a little bit different. So what is a highly compensated employee? This is someone who, under the current statute, earns, or the current rules, earns $107,432 per year. That's total annual compensation. That's not necessarily salary. They have to earn the minimum salary of $684 per week, as under the current rule. But the rest of it can come from bonuses, commissions, things that maybe are reducible or not guaranteed. It just has to be that their annual compensation exceeds $107,432. Obviously, their primary duties have to be in the office or non-manual work, otherwise they wouldn't be white collar. And they must customarily and regularly perform one of the exempt duties under executive, administrative, or professional employees exemptions. It doesn't have to be a primary duty. It has to be a customarily and regularly. Let's say our communications coordinator makes $110,000 a year. That's the first step. She is a highly compensated employee in that regard. And let's say she has two entry-level employees under her, but all they do is churn out press releases for approval. It's mechanical work that they're doing, but it might not be a primary duty that she oversees these other two employees, but it is an exempt duty that she customarily and regularly performs. So that might bring her under the highly compensated employee exemption. So the new rule, finally, we're here. This is an anticipated rule. They published it, the DOL published it on April 23rd, 2024. They had published a proposed rule, I think in September 2023, and invited comments from the public. As Ben mentioned, independent sector submitted a comment. The agency took all the comments, considered them, responded to them, and then formulated the final rule, which looked very similar to the original rule, and sort of explained their responses to all the comments in a 500 plus page publication, I believe it was. But what it does, it's very simple. It just raises the minimum salary thresholds for the salary basis test and for highly compensated employees. It's that first threshold issue when you're determining whether someone is exempt from the FLSA. It's going to be a multi-step process. It's not just one big jump all at once. It's two steps up, and then it provides for automatic updates in the future. And again, the duties test remains the same. So when you're looking at administrative, professional, and executive exemptions, that analysis is going to be the same. So what is it going to do in practice? So here we are currently at $684 per week, $35,500 per year, or the highly compensated employee is $107,432. When the new rule comes into place in July 1st, 2024, and so less than 2 months away, that's going to jump up to $844 a week, or $44,000 per year. And then the highly compensated employee exemption is going to jump up to 132,000, or about 133,000. And we're not going to stay there for long because January 1st, 2025, it's going to jump up to $58,656 per year and $151,164 per year for the highly compensated employee. After that, there will be another increase on July 1st, 2027, and those will continue every 3 years. Now, you might be thinking that this is just these look like arbitrary numbers. Where are these numbers coming from? So they aren't arbitrary. They they come from publication for data compiled by the Bureau of Labor Statistics. And this is what these salary thresholds have been tied to in the past. So in the past, what it has been and what it is currently is it's tied to a percentile, oh, excuse me, of the average earnings in the lowest wage region in the country, which is currently the South. So under the Bush administration and the Trump administration, they set it at the 20th percentile of the average wage earnings of average salaried earnings in the South, the 20th percentile. And July 1st, that jump, it just updates what the Trump administration did in, I believe, 2018 to the 2024 level of what the 20th percentile is. On January 1st, that's going to jump up to the 35th percentile. And then all future increases will be set at the 35th percentile thereafter. If this sounds familiar, we've been here before. The Obama administration tried to do this in 2016. They tried to move it up to the 40th percentile. But as we're going to talk about now, that was shut down. Under the Obama administration, 2016, sort of the closing days of the Obama administration, the DOL issued a rule that would tie the salary threshold to the bottom 40% of wage earners in the lowest wage region in the country. So that moved it up from 20%. They just wanted to immediately go to that level. A federal district court enjoined that rule from going into effect. It was challenged successfully. And then the Obama administration never got a chance to do anything about it because they left, the administration ended. And then a couple of years later, the Trump administration just stayed with that bottom 20%, but updated it from the last time that it was updated and during the Bush administration. We're expecting that there will be legal challenges that are going to be filed. This rule under the Biden administration is not judgment proof. It's insulated a little bit because the July 1st jump is still tied to the 20th percentile. But the January 1st jump goes up to the 35th percentile. So the argument's going to be if the jump in the Obama administration from 20% to 40% was too much, then what makes the 15 percentile jump any better? We'll see how that goes. As these things have gone recently, these challenges to executive rules, they tend to be successful because the organizations of people that challenge these rules have gotten very good at forum shopping and finding judges that are going to go their way. So it will probably go through a court that they believe is going to be favorable. I don't believe that a challenge has been filed yet, but we're expecting it. And there's also a more significant sort of vulnerability to the salary basis test as a whole. Last year in a dissent, Justices Kavanaugh and Alito basically said that they believe that the salary basis test itself is inconsistent with the act and beyond the scope of the Department of Labor's authority. Um, they said it's a question of whether it will survive if and when the regulations are challenged as inconsistent with the act. Basically, just inviting someone to come along and challenge uh, the salary basis test as a whole. So that could go away, and then the only thing that would be left are the primary duties tests. So um, that would mean that someone who has primary duties that fall under the administrative exemption or professional exemption or executive exemption um, could be paid you know, they would just have to be paid the minimum wage. They wouldn't have to be paid a salary. Notably, in that same um, case, Justice Gorsuch he wrote another dissent and noted that he lamented that the employer forfeited the issue of whether the salary basis test was unenforceable. So I think they have at least 3 votes against the salary basis test on the Supreme Court. And out of 3 other conservative justices, they would only need 2 more. So we'll see what happens. As of yet, I don't know what's bubbling up through the court, but that could be something that the future Supreme Court uh, will decide. So, notwithstanding the legal challenges, how can you prepare? This is, at minimum, it's a good opportunity to sort of maybe not audit, but review your organization's pay practices and worker classifications to take a stock of it and prepare for change. I think that it's probably likely that the July 1st jump will at least come into place. Whether the January 1st jump to 58,000 comes into place, we'll see. But the first thing you want to do, review your staffing, compile compensation data, who is paid a salary, who is paid as a non-exempt employee, what does the overtime look like, and then collect facts about their job duties, or those that at least would maybe fall into a gray area. This is more than looking just at your job descriptions. It's actually talking to them and figuring out what their primary duties are, because job descriptions are a good starting place, but they're not always the most accurate. Consider reclassification. Some employees might fall into a gray zone. You might have someone who's paid a salary of $40,000. And then when there's a jump, they will fall out. So you have 2 choices there. You can increase their salary, or you can reclassify them as non-exempt. And when you're considering whether to do this, it's important to look at your budget, consider the impact of what those salary increases would be, what the impact of paying more overtime would be, and then considering your policies. What is permissible overtime? Does it have to be approved? Are employees disciplined if they work unapproved overtime? What are your clock in, clock out policies? What are your timesheet policies? Things like that. And then finally, check to make sure that you're complying with the FLSA record keeping requirements. They require you to keep things like the employee's identifying information, their occupation, wage rate, hours worked, other things like that, for a minimum of 3 years. So always good to check to make sure that you're in compliance with that. And with that, happy to take questions.
Thank you very much, Chris. Lots to digest, lots to chew on, lots of questions coming in. And I will just remind people, thank you for submitting those through the Q&A function. So this is a bit of a chance to understand this issue and get some basic, as Chris said, hypothetical, factual questions answered. If you want to engage Chris and his team, They offer counseling, they offer draft policies and agreements, a full range of dispute resolution services, and you see Chris's contact info there on the slides. So we're gonna explore as many hypotheticals as we can over the next 20 minutes, but do want people to know that Chris and the Sheppard Mullin team are active and engaged law firm working hard on behalf of their clients. And we've tried to answer a few of the factual questions before, but Chris, I want to ask you a little bit more about the duties test for non-highly compensated employees.
Mhm.
Um, so can you talk a little bit about like, do they need to meet every single bullet on that list? Is it most? Is it any one and they're in the clear? You talk about that a little bit.
Yeah, it's not going to be it's there's no silver bullet. Sometimes you know and it's clear and sometimes you don't. But and it doesn't have to meet every single point in that bullet, but in every single slide or any one of the slides. But it just has to be their primary duty has to be really one of those things. And they have to fall into that. So the most important thing that they do, that's what you're searching for and figuring out. And whether that holistically brings them under one of those exemptions.
Got it. And some other questions about the work week, right? It's our understanding that FLSA operates on a 40-hour work week,
Mhm.
kind of regardless of what your individual workplace considers standard.
Yeah,
You talk.
so actually, employers, they have to, under the FLSA, they have to set what their work week is. So if the FLSA doesn't say, oh, it's going to be, Sunday at midnight until, 7 days later, it's the employer has to set that so that it's consistent organization wide. And it has to be noted in their record keeping what that is, so that when and if the Department of Labor comes in to say, we will, show us your records. We want to see if you're paying overtime or if you get, God forbid, sued for, allegedly not paying overtime when it's due. You can figure out how that is calculated easily. Because some organizations, they don't use a standard, Monday to Sunday. It can be different.
And if people are working 37 and a half hours a week and earning just below the exemption threshold, right? Their employer isn't allowed to say, well, if they were working 40 hours a week, it would be over, so they're exempt, right? It's a salary basis.
Yes, it has to be guaranteed salary basis. So, I mean, when they're working 37 hours a week and they're paid by the hour, it's not guaranteed that they're going to work 37 hours a week the next week. So you pay them for the hours that they work. Under the salary basis test, it has to be the minimum amount, and it has to be guaranteed of what those are. So right now with 600, I always forget the numbers are, but it has to be guaranteed $684 per week currently, and then after July 1st, it has to be a minimum of $844 per week.
Thank you. And you talked about organizations to which this rule applies. There is no exemption for, organizations with one employee or fewer than 10 employees, for example, right? It's based
It,
on anyone in interstate commerce.
yeah, yeah. So that's an individual sort of analysis, and the interstate commerce is that, like, each employee who engages in interstate commerce is going to fall under the purview of the FLSA. And again, it's important to know state laws and how those interact, because often they are more generous to characterize it than the FLSA. particularly with respect to minimum wage, but also overtime.
Uh, Thank you, Chris. I'm trying to pick the most relevant questions that we have here. Someone has a question about the definition of full-time employees and whether that can be, 4 half-time employees, for example. I think that gets back to some of the supervisory duties test questions, if they customarily supervise 2 or more employees.
Well, well, what do you mean? The whether they are full-time or part-time, you can be full-time exempt, you can be part-time exempt. That goes to what your duties are. Um, the question of whether they oversee someone else can be different. It doesn't matter if the person that they oversee is non-exempt or not. I'm not sure if that's the question.
Yeah, I think it is that over
Okay.
even someone whose duties include overseeing
Yeah.
uh, 2 or more part-time employees.
Oh, right. Yeah. Well, no, it goes to whether they oversee and supervise those employees as a whole, I think, would be the question. That's a interesting question. I don't know exactly the answer to that. I can't say with certainty, but I would believe it's just the fact that this person, this employee has the authority to oversee and direct and control the work of other employees, regardless of whether they are full-time or not.
Um, Stacy has a question, Chris, about the professional exemption.
Mhm.
And really about, is the bottom line annual wages? What if the employee is part-time and meets the weekly minimum, but not the annual?
The weekly minimum, that's the so the annual is just an annualized number. It doesn't necessarily have to be their salary for the year. It has to be when they work, they are paid um a rate of over what the weekly minimum is. Yeah.
It sounds to me like this is a question about sort of about seasonal employees in the city,
Hmm.
right?
Right.
So so someone who only works during the summer but works 60 hours a week, if they're under that threshold, then
Yeah.
they're
But
they're
if they're
required
paid
to be.
Yeah, if they're paid above the threshold, it's guaranteed for them in each paycheck. So you can see what their paycheck is. So a lot of people don't work for employers for more than 1 year. So they would not be paid, the full $58,000 or whatever it is at the time.
And an interesting question, Chris, about the pitfalls of an overtime policy that might require supervisor approval before an employee logs more than 40 hours in a week. Certainly you're plenty familiar with policies and procedures. When
Yeah.
you've seen policies like that, do you have any quick thoughts on that?
Well, I will say it's I know it's something that it sort of doesn't feel right. But you do have the authority as an employer to discipline an employee who works overtime without authority. And you can require approval before the employee works overtime. The thing is, though, once they do work overtime, you have to pay them that 1.5 times. That's where the FLSA kicks in, is if you refuse to pay them. But if they do work that overtime, it was not approved, um, then you can discipline them for working that overtime. So it's not something that I advise against. It's something that employers can include. You want to make sure that it's worded correctly. You can't say things like you can't work overtime. Uh, you have to say things like you can't work overtime without approval.
Uh, so while we're talking about seasonal employees, the question about anything changing the recreational exemption for seasonal staff. I know it goes maybe a little beyond our conversation today.
Yeah, and that's one I'm not read up on and doesn't come up that often. But I'm actually not that familiar with the recreational employees exemption.
Well, it's safe to say that in your reading of the quick 300 pages in this rule that really the only adjustments are to that salary
Yeah,
test.
yeah. It's not going to change um anything else under the analysis for the white collar employees exemptions.
Right. We're getting a number of questions about the highly compensated employee test,
Mhm,
Chris.
mhm,
Right, and I've described it as sort of just one additional avenue
mhm,
to where an employee can be exempt if they don't meet all of the exempt duties,
mhm.
right? So can you talk through that a little bit more?
Yeah. So it's basically looking at the primary duties test when you're looking at whether an employee falls under the highly compensated employee test. You say, oh, they're paid $110,000 a year. Maybe they're a highly compensated employee. So your analysis is going to be a little bit different because it's basically taking the primary duties test and turning it down a few notches. It's a relaxed standard. You're not looking to see whether they're doing, spending more than 50% of their time on exempt duties, or what the most important thing that they do and whether that's an exempt duty. You're looking at whether they customarily and regularly perform those duties. So it's maybe not something that they do isolated, and something that they do regularly that would fall under one of the exemptions. Maybe, for example, with the communications coordinator that I talked about. So maybe this coordinator, she mostly does, sort of non-exempt work. She's under sort of supervision um, from the higher ups or her supervisor. She's requires approval to do a lot of things, but she also um, talks to the press, or she maybe has the authority to publish, I don't know, maybe social media posts. She has control over the entire organization's social media presence. Something like that might be so would fall under the customarily and regularly performs an exempt duty.
I have a question about people who are paid hourly, even if they're paid hourly at a high hourly rate. Chris, can they be exempt from overtime if they're
No,
paid an hourly rate?
it has to be salary, paid basically a set amount every week, guaranteed. You're not considering the amount of hours that the employee worked for the purposes of their pay.
Thank you.
Mhm.
Uh, so similarly, if an employee this is getting back to people who work, for example, 20 hours a week. Uh, their employer can't take half of the 58,000 and make them exempt if they earn over half of the 58,000 working half, yeah, of the week. They have to actually earn a salary level above that weekly, that $1,100 threshold.
Yes.
Great, thank you. Um, Trying to pick the best use of your time today, Chris, for which we are so grateful. Um, can you talk a little bit more about the timing of the work week, how an employer sets that work week, and then the record keeping associated with it. You mentioned record keeping.
Yeah, so yeah, the employer or organization, it's one of those things that if you have a, a payroll provider, Paychex or ADP or something that you might go through, um, that's one of the things that they I believe they're going to require you to set, and you're going to have a policy setting what your work week is going to be. So it could be that it goes from um, midnight on Sunday to 11:59 p.m. on Saturday night. And then whatever is worked within that 7-day period, if it ever goes, if the non-exempt employee's work ever goes above 40 hours, that's when the overtime kicks in for that week. Now, as I talked about, there's some states that have a daily overtime calculation in addition to that. So if an employee works maybe more than 12 hours one day, then the overtime is going to kick in for that particular day as well. With respect to the record keeping, a lot of the records that are required to be kept under the FLSA are printed on paychecks. And so keeping those go a long way to the record keeping requirements under the FLSA for 3 years. And there are other things that you have to keep as well, policies and all of that kind of stuff. But that's sort of the things that are printed: the hours worked, the rate of pay, the period of pay, the employee's name and contact information, what their position is might be on there. Things like that are required to be kept under the act. It's a it's a pretty extensive list of things that are required to be kept under the FLSA for 3 years. But a lot of it's sort of taken care of with things that you would put on your paycheck.
And similarly around the work week, can do all employees in the organization have to have the same work week, or can you put your development staff on a work week that starts on Thursdays so they can work more hours over the weekend, fundraising events?
I think theoretically you might be able to, but I think it would create an additional administrative burden. And it might sort of, it might look like you're trying to avoid paying overtime to certain employees. If you have sort of shifting policies like that. I believe, we've had some unionized clients where their bargaining unit, the work week was set by the collective bargaining agreement, but it might not have matched up with what the administrative and supervisory employees were. But I would advise against having multiple work weeks, multiple different starts to the work week for one organization.
So we're coming up possibly on our last question here. It looks like we've gotten through 24 so far. So can a company, this is a multi-part question, Chris, can a company have all 3 types of categories: exempt, non-exempt, and non-exempt salaried? I think that answer is yes.
Yes.
And then for non-exempt salaried employees, are we only tracking time when they're over 40 hours? Or are we required to track all hours regardless if they have hit 40 hours?
You'd have to record all of the hours worked, because that's how you would determine when they hit the 40 hours and trigger that 1.5 times pay.
Makes a lot of sense. It looks like we can squeeze in one more quick question here. For the outside sales exemption, do employees need to be paid a commission as well as a salary? And if they're only paid a salary, but it's under the threshold, is that okay?
They have to be paid, the outside sales, I didn't expect to cover that today, but they do have to be paid, their salary, I believe, can go below, but their primary duty, first of all, has to be making sales.
Mhm.
And that's defined under the act. And that's, obtaining orders, contract services for facilities, uh, which consideration will be paid for by a client or customer. Um, and I believe that their commission, it's basically their total salary, or their total compensation has to meet the $684 per week.
Increased level, as it were, yeah. Right, so if they're paid only a salary, but it's under the threshold,
Right.
then they're entitled to overtime. And if their salary is under the threshold, then
Well, not if they're,
there's no commission.
I'm gonna have to, that's it.
It took us 61 minutes to finally find a question that makes some person.
Um,
We're happy to we're gonna so what we're gonna do, folks, for the questions that we did not get to today, if there is additional information that independent sector can provide and try to answer, we will try to do that. If you didn't get an answer to your question today and you really you really think you wanted to, you have our email address, publicpolicy@independentsector.org. We will do our best to answer those questions.
I've got an answer for you on the outside sales. The salary basis is not applicable. So it doesn't have to be a guaranteed $684 per week, but they have to be doing sales. That has to be their primary duty, and it has to be away from the employer's place of business. So traveling or tour, they're working with customers directly. Sorry to interrupt. It was
That's quite all
bothering
right.
me.
That's quite all right. Again, we're a couple minutes past the hour. We also know that some folks were unable to join right at the top. And so I will reiterate again that we will make this recording available, and we will do our best to respond to questions submitted to the public policy at independentsector.org email address. You are also more than welcome to engage Sheppard Mullin, international law firm that looks after their clients. So with that, we know that this is a big, important issue and not an easy one, but again, an important one for the nonprofit workforce. We're so grateful to our guest, Christopher Williams from Sheppard Mullin. And we look forward to staying in touch with you all in the days and weeks to come. Thank you all again.